You can bet there'll be more leaks, and they'll be trying to launder the information through supposed briefings that are required of people like Adam Schiff in Congress. Let's begin with the beginning, which is the current crisis as it relates at least to government corruption, or at least a core part of it, is the Biden raid, the unjustified raid on the home of former President Trump that took place not too long ago. It was, they tell us, about getting presidential records and potentially classified information back. And as Judicial Watch has highlighted, based on our experience on a similar case related to Clinton's tapes of Bill Clinton conducting government business, including communications with foreign leaders, which are presumably classified, the Justice Department, the Biden administration, and the National Archives changed their minds, did a 180-degree spin to go after Trump for these records, when in fact, when we asked them to do that with President Clinton's records, they said, oh, you can't do that. In fact, the fact that he has them after he leaves office means they're presumably personal. And then they go ahead and take the completely opposite position and raid Trump's home. Now, President Trump has tried to highlight what I've called the Clinton sock drawer case, because he kept these tapes supposedly in his sock drawer with the lower courts and with the appeals court, because of course the government appealed, to bring you up to date, the special master ruling by Judge Cannon. And they appealed specifically the part of the ruling that restricted the Biden operation from using for a criminal investigation, or reviewing for a criminal investigation or any criminal investigation, the supposedly classified documents that they seized from Trump's home. Now, of course, the argument is, as Judge Cannon noted, well, are they classified or not, given the issues that Judicial Watch has raised, or that were raised in the Judicial Watch case, and that was brought to the attention of the court by Trump's team. Now, the appeals court overruled Judge Cannon on that specific matter. So the special master's continuing to look at the other documents to figure out what kind of documents they are or aren't. But the classified records for now will be kept from the court, will be kept from Trump, will be kept from the American people, which of course is very convenient and helpful to the Biden operation. That has already leaked some of this material, or tried to describe some of this material, my guess is misleadingly, to news organizations, left-wing news organizations. And you can bet there'll be more leaks. And they'll be trying to launder the information through supposed briefings that are required of people like Adam Schiff in Congress. You know, so that's the situation we're facing. We're also facing a situation where the courts don't seem to understand the Presidential Records Act. Now, the Presidential Records Act, as explained by the court in the Clinton case that we pursued, and of course she was analyzing appellate court and Supreme Court cases about presidential records. The president is the decider in chief, and he gets to decide what are presidential records and what are personal records. And in the case of, let's say, Bill Clinton taking records with him after he left the White House, and they said, well, you know, we just presume they're personal. And the law, once that decision is made, gives no authority to the archives or anyone else in the federal government, the archives, the Justice Department, or the FBI, to second guess them. They don't have any criminal authority to go look and get those records, and they have no even civil authority to go and get those records, as Judicial Watch learned directly. Of course, the first rule of the Justice Department is to protect the Clinton gang and abuse Trump. So they changed their views on that and went after Trump. Now, Trump is trying to highlight this issue to alert the courts to it. But the appellate court wasn't terribly interested in it. I mean, one thing that the Trump team should be doing is that they should be more specific as they raise these issues in the courts, meaning it's one thing to say that you've got this Clinton sock drawer case out there and take a look at this. It's another thing to say that means these records are all personal. That means these records are all necessarily not classified and personal. that means all of these records are not, quote, presidential records. That decision's already been made by Trump, practically speaking, in that he has them. Now, of course, the left is mocking President Trump, even though, again, he's right. When he told Fox News' Sean Hannity earlier this week, is all he has to do is think about declassifying records, and they're declassified. And then he moves them, obviously, as it looks like was done when records were moved to Mar-a-Lago as he left office. And now the left is like joking, oh, you just can't think records to be. Of course, that's so dishonest. But what the president is saying is that he's reviewing records. He makes a mental note that I want to keep these as personal records. I'm putting them in this pile, and they're going down to my house. That's all that's required. So yeah, he can think that records are declassified, and as a result, him moving and shuffling the papers along to a certain pile, more or less, they become his. That's the reality of the law. And the courts don't want to grapple with it. They don't understand it. Judge Deary doesn't seem to understand it because Judge Deary, who is the special master who was appointed, and as I pointed out last week, Judge Deary is a senior judge up in New York. He's been around for a long time. He served on the FISA court. He approved, as I understand it, the fourth FISA warrant targeting Trump with this outrageous spying. You know, the cutout target was Carter Page, but the goal was to spy on Trump. He didn't question it. He held no hearing on it. And so what do you think Judge Deary's going to do when he's asked to, as he was initially asked to, figure out whether these records are classified or not? He's going to defer to the government, which it looks like he was presuming to do or getting ready to do until the appellate court ruled and took these records away from his jurisdiction. The same thing goes for the appellate court. They don't understand the Presidential Records Act. Now, supposedly there are 2 Trump appointees on this panel. It was a 3-0 decision, but I don't care. I mean, I dispute their analysis here. And I'm going to read you the key part here of this decision that the left is highlighting. Plaintiff suggests that he may have declassified these documents when he was president. Now, the plaintiff obviously is Trump. But the record contains no evidence that any of these records were declassified. And before the special master, plaintiff resisted providing any evidence he had declassified any of these documents. In any event, at least for these purposes, the declassification argument is a red herring because declassifying an official document would not change its content or render it personal. So even if we assume that the president did declassify some or all of the documents, they would not explain why he has a personal interest in them. And that was their analysis, meaning, well, he doesn't have a personal interest in them, so there's really no reason for the court to review them. Well, that's a fundamental understanding and kind of a logical fallacy of as it relates to the Presidential Records Act. The only way these records would have been, in my estimation, I shouldn't say the only way, the most likely way, and what's being argued here, is they would have been declassified in virtue of the fact they were in his possession and necessarily personal. So if they're personal, it means they're declassified. The Presidential Records Act assumes all these other records laws, including laws related to classified information. So the president could look at classified information, say, I want to keep this as a personal record, and it becomes declassified. And no one's allowed to second guess that. At least I don't understand how that could be second guessed under the law, and certainly the judge in the Clinton sock drawer case suggested that there was no way to second guess that. And she's one of the most liberal judges in the city up here in D.C. So do you understand, I hope, the kind of illogic and the failure to grapple with the Presidential Records Act? Now, some of that is they highlight, well, he didn't say he declassified them. Well, technically, he might have helped. And if I were Team Trump, I'd be really specific about these arguments as to why they apply to these specific documents. But they don't have to under this analysis of the law. And they've ignored that. They've ignored the application of the Presidential Records Act and his ability to make them personal or otherwise. So it was a judicial fail by the 11th Circuit in allowing the Biden operation to keep these so-called classified records secret still from the American people. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.